Well, good morning or afternoon to everybody, depending on what time zone you're sitting in here. Welcome to our latest edition of the NCTA On Track Live webinar. Appreciate everybody taking time out of the day to join us for the discussion today. We've got an excellent guest speaker with Pete Foll from Slover and Loftus, who will be joining us in just a minute here, talk about common carrier stuff. As you know, we record these sessions. We've had a great demand from folks who did have conflicts at the time, but go back and access the recording. So we very much appreciate Pete consenting to let us record this so that we can have it in the archives for other folks to enjoy. We always start with just a couple of newsy announcements. Tomorrow's On Track newsletter will have a little write up on some comments that National Coal Transportation Association participated with the Freight Rail Customer Alliance before the Surface Transportation Board on their new reciprocal switching proposal. We'll also have some links to other folks' comments on that. It's gone really interesting. Reciprocal switching has never been a huge high priority item on the coal transporters agenda because it's an issue that's of greater importance to manifest shippers. And what the STB ended up doing with their proposal was throw out about 8 years of work on a reciprocal switching proposal that was based on economic terms and kind of start over with a reciprocal switching proposal that's based on service levels. And when they did that, the initial reaction from lots and lots of shipper groups that had been asking for reforms in this space was kind of a, well, gee, thanks for doing something. But now that the comments are starting to come in, it's pretty clear that there's a lot not to like in this proposal. It doesn't seem like the shippers or the railroads or the labor or anybody's very satisfied with what's out there. But NCTA did participate with some limited comments. We'll link those for you tomorrow. One other newsy item to cover before we get started. Those of you who are shippers that are subject to the UMLR exemptions, Melinda has sent out all the UMLR notices already and is starting to receive some of those back. But if you are an UMLR shipper and you've misplaced your application or so forth, make sure you get with Melinda. I'm sure she'll send out one more reminder before the end of the year here. But if you're able to take advantage of that program, now is the time of year to do it. We are coming up on the end of the year. We're excited. Next year is going to be this is the shameless self-promotion portion. Next year's going to be NCTA's 50th anniversary. And we've got a lot of fun stuff coming together, a lot of good ideas for how to celebrate that anniversary. In the next couple of weeks here, before the end of the year, you'll see some new branding rolling out on NCTA. We got a shiny, spanky new logo for our 50th anniversary and some new sponsorship programs that will be rolling out with that. So please keep an eye on the On Track newsletter and in your inbox for news about those things coming out. And as for the calendar, we are going to continue with these On Track Live webinars at same time, same bat time, same bat channel every month here on the whatever Wednesday the month is. Our next one will be scheduled for December 20th. Again, I know that's getting dangerously close to the holidays. But we will be recording them, so you'll have the benefit of that. But our speaker on December 20th is going to be Richard Edelman. He's he's a labor lawyer, and as I think you'll see in some of what Pete has to talk about today, you know, the positions of the labor folks are playing a role in what's happening in transportation policy these days, and so it's nice to get a labor person's perspective in December. In January on the 17th, our special guest will be Railway Age's Capitol Hill contributing editor Frank Wilner. And Frank's been around forever and has some great insights on what's happening. He also just published a new book on railroad economic regulation that I'm working through and learning a lot. So it'll be great to talk to Frank in January. Our operations and maintenance conference and spring conference are back to back, May 20th through the 23rd. It's going to be in Chattanooga. We're at a great hotel, the Chattanooga Hotel. Melinda's putting together a fun dinner ride on an actual train. We've got lots of sponsorship opportunities available for that too. So get a hold of Melinda if you want to get in on the ground floor of some of that action. And then we have finalized the dates for our fall business meeting, the 50th annual business meeting and conference will be held next September 9 to 11. September 9 to 11 dates have been finalized finally, and that will be in Tucson, Arizona, in a lovely historic property there at the Hacienda del Sol in Tucson. So we'll come out back west next fall. So that's kind of the rundown of latest news and what's going on. I'm very pleased to introduce our guest speaker, who's prepared a few slides for us, and then we'll have a conversation after that. Pete Full, he's a frequent speaker at some of our conferences with Slover and Loftus, excellent railroad transportation attorney. Should have looked up your bio, Pete, and come up with lots of college references and things to make fun of, but I didn't know that. I think a lot of the folks here already know you, but Pete, thank you so much for taking time out of your schedule to prepare some slides and be ready to talk to us. This issue of common carrier is all over both the Surface Transportation Board and some activity in Congress now. And, it's an easy thing to say, but a hard thing to understand. So we appreciate Pete lending his expertise to give us all a primer on common carrier and what kind of moving parts are going around that issue now. So Pete, did you have some slides you wanted to share to start?
I do. Let me lock those in here. Okay.
Bingo. They're showing up. You might want to put it in freeze. There you go. Everything's great.
Okay. And I apologize. One reason I have a lot of slides, I'm going to go through them quickly. The reason I have so many of them, and some of you on this call may have seen portions of this presentation before, but it gives. I felt that it was helpful to have them because it gives a historic background on what is the common carrier obligation and puts the current service situation and common carrier obligation issue in context. I thought perhaps we would whip through these pretty quickly. Then you have them afterwards if you want to come back and look at individual sites. So going back and the establishment of the common carrier obligation, it really goes back far in time to pre-common law doctrines. And the old common law doctrine said carriers have to receive all goods and passengers, although if his coach be full, he's not liable for failing to transport more than he could carry. It's really a reasonableness type of doctrine that's been around a long time. Part of the U.S. doctrine for over a century. And really what the doctrine is that it's supposed to be that the railroads are treated as a quasi public utility, which most of you know about, an obligation, a higher standard of responsibility than a regular business that you deal with. And that's supposed to mean something. So it's a statutory obligation today. It was added to the law in 1906 and then further amended in 1920 in the Transportation Act. And so those acts gave the duty of the then ICC and now the STB the authority to implement it and to ensure that shippers have an opportunity to use it. The current statute it's a very kind of open-ended language they use, that rail carriers providing common carrier transportation shall provide the transportation or service on a reasonable request. And so one can see just by that language why there's been confusion. What is it reasonable request? What does it mean? How is it implemented? And why are shippers and actually rail labor, why are they come together recently to seek some meaningful changes, or at least some definitions put in the act to assist the STB. It is a doctrine it's applicable just like the STB. The STB doesn't have jurisdiction over contracts or exempt traffic, which is not coal. Of course, coal is jurisdictional traffic. So it's really for common carrier traffic that it applies to. So the board has the authority to regulate common carrier activities in several different ways. One is rates. Rates must be reasonable. Practices. If the board finds that a practice of a carrier is unreasonable, it can order the railroad to cease and desist and adopt a reasonable practice. And an example of that would be the rail fuel surcharge. Percentage of rate fuel surcharges that the board in 2006, I guess, determined to be unreasonable practice and ordered the railroads to change them. And then finally, service is what we're all been attuned to in the last couple of years. That the obligation is the obligation to provide service, adequate track, equipment, facilities, whatever it takes to move the traffic in a reasonable manner. And then if there are times of floods or shortages and they're beyond the railroad's control, then the general case law states generally that a railroad has to apportion its available capacity reasonably amongst its customers. It can't pick and choose winners and losers. So the board, as I mentioned, has implemented the unreasonable practice and the common carrier obligation in a general way in certain occasions, and one of them, as I mentioned, was the rail fuel surcharge prohibition on percentage of rate fuel surcharges. But for the most part, the board has decided these things on individual adjudications. And so what they look at is what is reasonable. They look at it on a case-by-case basis, on a fact-specific basis. And it is, I have a case here because I think it's an important case. The Pejepscot case, which stated that a carrier can't lawfully make fulfilling their statutory obligations contingent upon whether they think it's worth it to do so. I think many of you start to question at times whether or not, are you the customer of the railroad or the railroad the customer of you? And the railroad really, it's beyond that. I've got listed here a few of the cases that this issue, nobody's really challenged. There hasn't been service cases in a number of years, but that's changed in recent years, really probably because service has gotten with positive train control and with the railroad's practices of changing their economic focus on short-term gains and precision scheduled railroading. They've moved away from service, obviously, and you all know that. One of the first couple of cases here, the Hasa case, was actually a chlorine shipper that served customers in California. Union Pacific served them out of nowhere in the peak season for delivering chlorine for water treatment and frankly for pools and other recreational uses. But for essential drinking water safety issues, Hasa needed to receive 5-day-a-week service, and it had been receiving 5-day-a-week service from UP for decades since it built its facility. But with precision scheduled railroading, UP Omaha office called them and said, we think the metrics show we can serve you just as well 3 days a week. And it unilaterally shut down its service from 5 to 3. A similar issue was with Sanamax, which was an animal waste entity that had been outside of Chicago, or actually that was in St. Paul, Minnesota, that had been receiving 5-day-a-week service from UP for a number of years, and UP again, and similarly, unilaterally decided to cut service from 5 to 3 days a week. So Hasa brought a petition at the STB seeking preliminary injunction that UP must be required to restore its service to 5-day-a-week service. And actually, in one day, the STB granted that petition. UP fought it. They tried to appeal it. They tried to, get around it, but ultimately the parties did settle that case, and I think HASA was able to keep its service to 5 days a week. Sanimax was a little bit more complex because Sanimax involved an exempt commodity that the STB had declared that the commodity involved, the animal waste commodity involved, was not a regulated commodity. So it had to navigate its way around that. But ultimately, in a decision in 2022, the board did give it injunctive relief. And just recently, in the last month, the board, Sanimax had not sought damages. That's another thing from a common carrier obligation case. In addition to restoring service, you can seek damages. The board said, you didn't really ask for damage or say much for damages. Why don't you guys brief us on damages? And so that the issue of damages, if Sanimax decides to seek damages, will be an issue that will be continued to be litigated, and that matter remains pending. Foster Farms was kind of the first case that got a lot of attention. It was a shipper, Foster Poultry Farms, that grows lots and lots of chickens in the Central Valley of California, and those chickens need feed to be able to survive. And UP, and not only that, it was such high volumes that they're moving unit trains of feed to the Central Valley, and UP had failed to serve them and put the chickens in peril and the operations in peril. And the board did, on a couple of days' notice, order them to restore service. They found that the UP service failures require the issuance of an emergency service order. They directed UP to deliver the service they needed and required them to report going forward periodically on how well they were serving. And then that was back in summer of 2022. And after the service was subsequently restored, the matter did close at the end of last summer. So I think the service situation there is taking care of itself. So those are all UP cases, and UP has kind of been, the board's been pointing its fingers at them for a lot of stuff. But there's the one that's probably most interesting to you is the NTEC case. That's the case which I think many of you have heard about. Navajo Nation owns the Spring Creek mine, and the BN it's exclusively served by BN. It's export coal. It goes up to Canada to around a terminal near Vancouver. The coal is loaded on the ships and then to customers in Asia. And in 2022, it was a large volume coal shipper. In 2022, the NTEC sought to ship somewhere in the vicinity of 5.5 million tons of coal, but BN cut off its service to about 3.1 million tons, and told NTEC, sorry, we're just not required to ship anymore. They were under contract at the time. That contract expired, and I think NTEC, eyeing the possibility of bringing an action and not being able to get the relief it needed under its contract, asked for common carrier rates. BN, as a common carrier, has to provide those rates. So provided the common carrier rates as it's required to do under the law, that opened the door for NTEC then to bring a service complaint, service failure case at the STB. They filed an extensive pleading with verified statements showing how BN had failed to serve them. There were other coal shippers that came into that case, other competing export coal shippers, not utility shippers. But they came in and did express some concerns. If you grant the relief to NTEC, what does that mean for our service? But the board basically said, listen, BN testified on the record that they could move at least 4.2 million tons of coal a year. And so we're going to require them to do what they say they can do and serve all other customers and not anymore. And so after a hearing and I think it was about 30 days later, the board issued an injunctive relief decision. It did order BN to provide the 4.2 million tons that BN said it could provide. And it also ordered BN to provide service of an additional 1 million tons if BN could reasonably make resources available. And it required BN to issue periodic service updates on reports. And so BN vigorously appealed that, both before the board and the Fifth Circuit, saying the relief granted was wrong. The STB was unfairly picking winners, it said. But last week, on November 9th, the parties announced that they had they reached a settlement agreement, and they moved to stay the matter until early next year and to allow them time to wrap up their settlement discussions. And so those are four relevant recent cases where this is not just a theory, the common carrier obligation. People have actually used it and been successful in obtaining relief before the board. So I did want to spend a little bit of time, John, on those. So, when going forward, looking at, the issues, obviously we have the issues that you've all faced, the service disruptions, but there's other issues and practices that people have been concerned about that could be subject to challenges, such as, accessorial fees. You guys have faced new unit train laydown charges, locomotive use fees that are in tariffs. UP's really pushed on those. Service embargoes. We haven't seen embargoes so much on utility unit train shippers, but for other shippers, I've seen a lot of clients where UP and other carriers implement so-called congestion embargoes that aren't related to any weather event or any unforeseen event at all. It's just a method for them to try to get their traffic rationalized in a manner they think they need to rationalize it. Liabilities, obviously, after East Palestine, is a huge issue, and the railroads are increasingly seeking to shift liability on customers. And we're seeing that more and more in tariffs. All these are subject to unreasonable practice type complaints. And then what I mentioned here, and which gets us to the next slide, was this relief is great, but should it really take an entity like Foster Farms that's facing livestock peril, or HASA with safe drinking water, to need to come before the board to get relief? Shouldn't we be able to get relief? Shouldn't we be able to get standards and relief more readily than having to go this full length? And so that gets us to the legislation. I think there's been concern that the STB still hasn't been doing enough. And here we really do have kind of a unlikely alliance of labor and shippers. Labor has always, over the years, been, you'll hear about this more next month, they've always been on the side of the carriers whenever it comes to anything related to economics or service, for fear that shippers are trying to take away resources that labor have. But you've all heard the complaints of labor about these types of precision scheduled railroading efforts that have caused their members problems and put safety and other things in jeopardy. Here's a letter back in 2022 in the June that the transportation union sent, talking about these things, that the railroads, even before the pandemic, reduced their workforce significantly. They deliberately have decided to reduce expenses and resources, and these things need to be looked at more closely. And so the labor did come to us and to other shipper groups and said, let's talk about this. And they said, we firmly believe that the common carrier obligation, putting teeth into the common carrier obligation, is something that could help us and help you, because it would require the railroads to put the resources back that they should have and be able to reasonably serve customers. And so we're both helped out by this. And so there was at first a statement of principles that shippers and labor entered into, and that and here's a list of groups and of labor groups and rail shipper groups that were in accord on this. Then moved on to legislation, which gets us to the Baldwin bill, the Reliable Rail Service Act. So the legislation is really designed actually to do things that I think that these cases can't do. The first thing is, provide teeth to the common carrier service obligation. I read earlier that the section 11101A requires service on reasonable request. So what was missing there was that when you ask for service, you should also be able to get service terms. And so what we sought to do with the legislation is put in language that in a manner that meets the shipper's need for timely, efficient, and reliable service, fulfills the shipper's reasonable service requirements. So that you should be able to get something service standards, and you should be able to get them upfront. And this gets us to the next section, that when you ask for common carrier rates, the statute would say that the railroad provide those terms, including reasonable transit or cycle times, or other service standard as requested, consistent with the needs and requirements of the person on whose behalf the request is made. This is all verbiage and lawyer language designed to ensure that the things that you guys can't get anymore, cycle times that you could get 10 years ago, you would put back into place if the common carrier obligation is going to have any meaning. That's the type of thing that unit train coal shippers need: reasonable cycle times upfront that meet their needs. And then the language also states that the railroad fails to provide you with those reasonable transit or cycle times or other standards, that the board could resolve any disputes, and it has to do so within 45 days. And it can prescribe reasonable standards and terms. And so that's the first part. And the second part, that if a carrier violates the common carrier obligation, the board has to conduct an expedited proceeding, conclude it in 6 months. And so the criteria is set here that in looking at whether or not they violated the common carrier obligation, the criteria is such that it looks at the needs of the customer. It also takes into consideration, the carrier's issues that they might have that are legitimate and reasonable, but the focus should be on the needs and service requirements of the customer. And these are the types of things that the legislation implements. So what's gone on since the legislation was introduced? Well, I think the board and Chairman Olbermann has held hearings on service issues, and including the STB's or the UP's service embargo. But now the recent phenomena where UP is issuing more and more of these congestion embargoes. And the question is, though, what else is there? What does Olbermann say about this? And so far, he initially said, well, we'd welcome the Congress to step in and help us. But more recently, when asked again at subsequent hearings, he said, well, I think the STB has all the authority it needs. And so that has put somewhat of a damper on the legislative front. In addition to the fact that with, rail labor and shippers, we've primarily only gotten the support of mainly Democrats, although there is one Republican co-sponsor of the legislation. But I truly believe that just having the legislation out there, all this legislation and other pro-competitive legislation that shippers have pursued in the past, it's obviously a juggernaut trying to get anything through Congress. But just by having it there, the NTEC case was a 3-2 decision. It was it essentially was 3 Democrats versus 2 Republicans. But I think the board wanted to show the world that we can actually utilize the standards and the law that we have today to grant relief if a shipper comes before us and it was a controversial decision and they moved ahead with it. And I truly believe that having that legislation there, putting pressure on them to do more was a helpful step. And a reminder to us that we're not expecting all this legislation to move quickly or to even pass, but these types of things do help put pressure on the agency. We haven't seen any STB movement towards any kind of rulemaking on the common carrier obligation. The STB has proven it can act when it wants or needs to. We're hoping there's another part of this too. The board has the authority to implement penalties under the act. They've never used that right. And so that would be the next step as well, to discipline the railroads. And so that's something else that I think many of us practitioners have recommended going forward. So John, that's a long-winded presentation. Hopefully I didn't take up too much time. But that gives you the overview as I see it with the common carrier obligation.
Not too much time at all, Pete, and I appreciate that. That was very, very well put together and practically thought out. Reminders to everybody, if you've got questions for Pete, this is not just a presentation. We can turn it into a conversation. So you're welcome to unmute yourself or raise your little handy thing or type into the chat box. I've got that live here. Couple of clarifying questions to get started, Pete, just to make sure I'm understanding it correctly. So if you're a contract shipper, you're outside the bounds of this common carrier obligation?
Yeah, you are. The board's been clear since the Staggers Act of 1980 that it only has jurisdiction over common carrier rates and service. So that does put most of you, obviously 90+% of unit train coal shipments move under contracts. But I'll say that the one thing that to keep in mind on this is that contracts come up for renewal every 2 or 3 years. And when you enter into contract discussions and you start talking about these types of things, transit times, reasonable service standards, there is a backstop. And in the past, the railroads have kind of laughed if you say, well, we may have to move to obtain a common carrier rate if you're not going to play ball with us and negotiate reasonably with a contract. With these types of complaints and the showing of the STB that it has a bit of a backbone, the threat of the possibility of you seeking a common carrier rate and seeking common carrier service terms, I think can be helpful in your negotiations. And it's something to keep in mind as you negotiate contracts with the railroads.
And is that process an either or thing? I mean, can you have a contract but also seek a common carrier rate, or do you have to give up your contract in order to pursue the other angle?
So the way it works is, and there's some Byzantine decisions on this, the STB has said basically, as you negotiate your contract renewal, you can ask for common carrier rates and have them in your back pocket if you need them. And as you continue to negotiate, they said there's a time limit. It's usually about 3 to 6 months prior to the expiration of your contract. You can go out and seek common carrier rates. You're not required to use them. They're just there and available. And so if you fail to obtain reasonable contract rates and service terms, then you have that as a backstop to use. So there is simultaneous use, I think, can occur.
Right. Your last slide, you mentioned the NTEC BNSF settlement that they're working out now. Couple of questions. I presume that NTEC brought cases both in the courts and at the STB, both an STB claim for relief and a common carrier suit in the district court. Is that correct?
That's right. And yeah, I didn't mention that I mentioned that they had been under a prior contract in 2022. They had brought a case complaining failure to meet the service standards of their contract. So that was a separate case, and part of that was actually being arbitrated. all of those, they did file with in court as well, stating that those are all being settled.
So presumably both the regulatory proceeding and the litigation are being
Yeah.
settled at the same time.
Yep.
And your
So
last slide
the
said
past wrongs and the present wrongs all being wrapped up.
yeah, and if we can find a way to wrap up future wrongs, we'll be all together. You mentioned on your last slide that, you know, this is a positive development for shippers generally. I mean, is that just with BNSF, or how does that translate into a positive development for folks who may have similar situations with other railroads even?
I just think that many of the people on the line today that have seen Chairman Overman and have seen his bark at hearings, laying into railroads about their unresponsiveness, have said this has been, you know, so refreshing. It's been great. Show us the beef. Where's the bite? This shows that there is some bite too, and he's not afraid. He's not afraid to move forward, and actually, some of these proceedings could have been stalled out like the STB likes to do, and we've seen repeatedly for years. But they granted relief on, you know, very fast basis, and almost all of these held a hearing for several days in the NTEC case very quickly. The shipper got relief. I was involved representing HASA, and that initial relief was enough to get us a meaningful settlement. That's all. In fact, I was at a STB practitioners forum this week, and basically told the chairman separately on the side, you know, the relief you're giving here gives us help because it does show that you guys have a backbone. You're not afraid to move forward when you have to. So this is something that all the railroads are looking at, and that the possibility or the threat of litigation is real, and the repercussions are real. And so maybe we should act a little more reasonably going forward.
So
they're still the railroads. They're still going to act the way they act, but this is a helpful move in the right direction, helpful step in the right direction.
The threat of your mom taking the car keys is as good as mom taking the car keys. Question from our listeners: are there expectations that the Baldwin bill will move forward, and is there enough language in the legislation to enforce the common carrier obligation on the railroads?
So I think with the Republican control of the House, it doesn't have much hope to move forward unless more Republicans get on board. At the meeting I was at earlier this week, House and Senate staff both remarked on it. They didn't necessarily have bad things to say about what was in that legislation, but they did indicate that they, you know, at this point in time, they didn't see that bill moving. There was an initiative by when the House was controlled by Democrats, the last Congress, that the chairman of the House Transportation Committee, DeFazio, was going to move this as part of a larger bill and a package of must-move legislation. It didn't work out that way. That's the way you could possibly move something like this. They've been talking about the Rail Safety Act and changes there. You know, the railroads would resist with all efforts any kind of attachment of something like this, but that would be the way to do it instead of a freestanding bill. And the question about whether or not the board has the authority, it certainly does. The common carrier obligation is, yes, it's general and it's ill-defined. The STB could do all this on its own. It just hasn't done it. And so I think it has and Chairman Oberstar is not wrong that they have sufficient authority if they choose to use it. And they could be doing more on their own. And maybe that's the next step as well, to push the board to do some more with this.
which kind of brings me to the corollary question then, which is, you know, the fact that there have been some relief recently in things like Foster and the peer pressure on the NTEC case. You know, is Marty Oberman going to stay the chairman, or you know, what happens if, you know, Marty's at the end of his term? You know, game that out for us. Is Marty going to look for another term? Is he going to leave? What happens if he goes? You know,
Yeah, that is a good question. And it depends on who's the president. Because the president gets to appoint the chairman, and it would be 3-2. If it were Republican controlled, you can expect that this might change. That the two Republican dissenters, their views that it's inappropriate to give this type of relief, emergency relief is inappropriate, and we shouldn't do it. So you could expect a change. The other thing that's a little concerning about, you mentioned at the very outset, John, the ex parte 7-Eleven. You know, if the STB's answer is the common carrier obligation issue is resolved because you can potentially get reciprocal switching in a defined limited terminal area if you can show that your service is degraded, that's not good enough. You know, that's not what people are looking for. That's not something that can help unit train coal shippers. And frankly, even most manifest shippers can't take advantage of that. That also requires a second carrier that's willing to compete, and you know, that's tough too.
And I think the other element that came out in a lot of the group's criticisms on the reciprocal switching proposal were, you know, that this switch from an economic viewpoint for why it's necessary to a service level, you know, also could allow gaming of the service levels. I mean, you know, if I just make my service gradually worse, you know, how do you ever?
Right. If you have to prove that your service is degraded 20 or 25% from the base year, and the base year is one of the worst years of service you ever had, you know, what good does that do? And you're right, it can lead to gaming for sure.
Right. You know, and again, we're kind of coming down on time. So if you've got more questions, please feel free to put them in the chat box or reach out. You know, is it, you know, a lot of this you know, I've never worked for a railroad. You know, I've never been inside the railroad. I mean, do railroad people wake up every day and think of their common carrier obligations, or is this more like one of those things that's out there that we have to comply with, but it's not what's driving my decision making?
I mean, that's right. I mean, obviously they seek to. Yeah, I think the folks in the coal departments that the utility coal shippers are dealing with on a day-to-day basis, they may have some thoughts and state that they care, and they're trying to make sure all the sets that you have are efficiently utilized and everything else. But ultimately, upper management and these larger decisions of what the network requires from a network efficiency vantage point, those efficiency vantage points are aimed directly at what's best for the railroad's economic bottom line. And so that's why, you know, when you say, hold on a second, you're a public utility type. You're supposed to be acting like that. That's why we need the regulators and we need Congress to continue to reinforce that this isn't just some words on paper in the statute. This actually means something. And having decisions like we've seen here can start to help. I do think they need to go further because it certainly is not ingrained in the marketing managers or the operational managers that service is our number one priority and goal. Service for themselves to meet their own requirements is their number one goal, but not the customer.
Right. Interesting. And so, you know, when we kind of summing it up, when we think about this whole common carrier obligation, correct me if I'm wrong, my takeaway from this is that, you know, some piece of legislation or a particular rulemaking at STB is not likely to be a silver bullet that obviously, you know, turns rail service around, but rather should we be viewing common carrier as a one of the arrows in the quiver that you can employ in contract negotiations or in regulatory settings to try to encourage better behavior. Well, it may not solve everything.
No, I certainly think that you need to utilize this renewed focus of the STB on the service as a point of emphasis in negotiations. Recognizing the railroads to say, yeah, I know there are some decisions. We recognize we have a common carrier obligation, and try to at least push them around the edges and getting some better terms and standards, whether or not you can get a cycle time that's meaningful in your contract with penalties for failure to meet your obligations is another matter. But I think we have seen some movement there, and part of it is beyond that, which goes to competition from gas-fired, product competition type of stuff that is driving that. But this is part of it too. Listen, if we want to keep moving those volumes we've been moving, you've got to meet our needs, and so part of it is the regulatory risk, and part of it is whatever incentives or whatever leverage you might have from product competition and other things that you could bring to the table.
Right. Made me think of one other question, Pete, and that is, obviously anything that a regulatory body like STB or any other regulatory body does is always subject to litigation afterwards. We've had a moderately more active STB now doing some things like the emergency service orders on STB or their pretty quick NTEC decision. How have those things been holding up in court, and how big of a risk is that? If I do try to use this common carrier obligation as a negotiation strategy, am I just setting myself up for a lawsuit after I get some initial kind of relief, and how is it holding up in the courts?
So the NTEC case was the only one of those four I referenced that had been appealed. I think NTEC would have prevailed. I'm fairly confident in that. Because I think that the law is broad enough to allow them to have done what they did. The one thing that BN had some hope on is, okay, it's one thing to say that we failed as a common carrier, we didn't meet our service standards, but in order to prevail, a preliminary injunction, you have to prove irreparable harm, that it's a likelihood that you'll prevail on the merits. That's how you get upfront injunctive relief. That is a tough standard. But I'll tell you, at those hearings that the chairman presided over, and he obviously is a former litigator, the stuff coming out of the railroad's mouths was remarkable about, what their basis was for restricting service, and was there truly resource constraints the way they said there was, and is it true? Why is it that you can't serve more than one shipper at the same time? That type of stuff they did not have good answers, and so the record on appeal was very unfavorable for the railroads. So I feel confident that these types of decisions would be readily upheld. Doesn't mean you don't have to go through those appeals potentially, but really most of those other cases were all settled after they got the injunctive relief against them. What happened was what the board wants to happen is the parties coming together and reasonably settle after the STB shows a little bit of backbone.
Great. One more question from the group. If you're a coal shipper and reciprocal switching can't help you, there's no way to enforce common carrier obligation, and you can't bring a rate case, what recourse do you have to obtain rate relief or reliable service?
I mean, unfortunately, you're stuck in a market where you're dealing with a monopolist, and absent some sort of proof that they violated the antitrust laws, there's not a lot you can do. If you're a contract shipper, the only thing you can do is at the end of the contract term, move to common carrier service and then fight the battle of the STB like NTEC did. And so you have to, the only threat is the fallback of a possibility of a regulatory remedy at the expiration of your contract. But there is, like I said, NTEC did have a contract, state law contract claim filed against BN for failing to abide by its service obligations. These types of contracts, oftentimes the railroads will have minimum volume requirements, and yet they'll say we have no requirements on our end. There is a fundamental duty under state common law of good faith and fair dealing. And I really think some of the tactics by the railroads come very close to violating, if not, I think in the NTEC case, we're way over crossing the boundary of violating that good faith and fair dealing. So a contract claim is the only claim you have under the limited relief provisions I know that the railroads allow you to in these contracts.
Understood. Great. Well, any more questions for Pete? It's been a very illuminating discussion. I've learned a lot. Thank you, Pete, for putting in the effort and for taking the time to join us today. We will have this recording available for anyone else that in your companies or anyone else who needs it. Just reach out to Melinda and she'll be able to give you the link. We will also put that in the on-track tomorrow as a reminder to folks that the piece is available. But again, thank you very much, Pete, for pitching in and making us all a little bit smarter today. And we'll use my favorite post-COVID virtual meeting cliche now and say we'll give you back 7 minutes of your life. Say goodbye.
Glad to be here. Thanks, everybody. And if you have any questions, feel free to pick up the phone anytime too.
All right. Thank you, Pete.
All right. Thanks.
Okay.